Welcome back to Nonprofit Human Resources. This is Andrew Sears, and I'm here with Angie Kreiner, who is the owner and a consultant with Career Cross Training. And this week is going to have a lot of content to go through. We go through human resources best practices, policies and legal issues, but this presentation is going to really be focused on the legal issues. Now, you should view this presentation almost like you're reading the table of contents in a book. And this book would be like probably 1,000-page book or more. So don't expect that you're going to know everything in the book. But we want you to know what the chapters are, so you know where to look, or if you talk with a lawyer, you know where to look and you know what things to look up. So this is going to be an overview. A lot of this stuff is really important, but it's also fairly complicated. And Angie is one of the top experts. She is the top expert I know on this, and these laws keep changing. So Angie, do you want to just kind of give an overview of some of the key laws that govern employment?
Sure. And I think what you said is really important, is just like you guys are peeking into the table of contents, please understand that I am not an attorney. This is not legal advice. And that in no means is the information that we're going to provide for you today completely whole. So that's really important for you guys to know. We want to give you a good overview. So the first one is the Fair Labor Standard Act, or FLSA. And this primarily regulates kind of the employer-employee relations. We'll get into this a little bit more, but it regulates the work week, minors in employment, et cetera. The Civil Rights Act, Title VII, is the federal law that primarily focuses on discrimination in employment and equal opportunity in employment. And again, I guess I should have said, these are all federal laws that we're looking at. The third one is a bona fide occupational qualification exemption. This falls under civil rights. And what it says is that the civil rights law, you guys have seen it probably in most places. We don't hire, or we don't make decisions in hiring based on race, age, gender, religion, etc. Those are what's called protected statuses. A bona fide occupational qualification permits when a position requires one of those things that is otherwise not permitted to be considered because of discrimination, that it permits it to be so. So if you're hiring somebody to be a night supervisor over a boys' home, you could hire a male for that job if the position required it, for example. We'll talk more about it, but Americans with Disabilities, this is a federal law that says that people with disabilities, whether temporary or permanent, should be afforded the same opportunities in employment, provided that there could be a reasonable accommodation so that they can still fulfill the essential functions of the job. Family Medical Leave Act, FMLA, is the federal law that says that certain employers and certain employees are eligible for up to 12 weeks of unpaid but job protected leave when certain things occur in life, usually around illness of the self or injury or a new baby. So Patient Protected Affordable Care Act. This is one of our newer pieces of legislation. And this is the one that regulated that employers are responsible to provide their employees with health care if the employers are of a certain size and if employees work at least 30 hours or more a week. And G is at-will employment. At-will employment is more of a doctrine as opposed to a law per se, but basically 49 out of 50 states operate under at-will employment. And that essentially means that either the employer or the employee can end the employment relationship with or without cause and with or without notice. So these are federal. We're going to take a closer look at them, and then we're going to talk a little bit more.
One thing I would just add, 90% of our students are based in the US. We get about 10% of our students that are outside the US. And if you're in a different country, especially if you have a pretty well-developed legal system, you're probably going to have laws that you should view these more as principles, and you're going to have to figure out, we can't cover, all the laws in all the countries, but you're going to have to figure out, does your country have something comparable? Europe has a lot of similar laws. They generally have more than the US does. And if you're in a developing country, often there'll be less on these things.
Canada does as well.
But if we're going to talk about law, we pretty much have to talk about the U.S. Context for this course, just to explain that. So if you want to, yeah, talk about the interplay between federal and state laws, Angie.
All right, so essentially, if there are both federal and state laws on any subject, the applicability is whichever affords the employee the greatest benefit. So for example, minimum wage. The federal minimum wage in our country is $7.25 an hour for hourly employees. Many states set a higher minimum wage. I live in Colorado and the current minimum wage, I think, is $11.15 an hour. And so anyone who works in Colorado cannot make less than the state minimum wage because it's greater than the federal minimum wage. In the absence of a state law, then the federal law applies. So there are some cases where states, to keep the same example, have not set a state minimum wage. In that case, federal law applies. Commonly, laws apply based on the type of employer. And within the US, we have government employees, we have public sector employees, we have private sector employees. Within private sector, you've got for-profit and nonprofit. And within nonprofit, there's a number of different subsets as well. So there are laws that apply to government employers differently than public or private sector employees and so forth. So it's really important when you take a look at the different laws that you also understand the type of employer you are and understand the applicability of those laws. And the second most commonly applied criteria is the number of employees or the size of the employer. Most federal laws kick in at 50 or more employees, but many of them, like civil rights, are as low as 15 or more. So it's important to know that as well. Laws that are commonly addressed by the states that are not addressed by federal law are meal and rest periods. That is a state-by-state thing in terms of employer-employee relationships. Employee access to personnel records is another one of the laws that a state might say something about, whether or not vacation is compensable upon separation. In fact, a lot of people don't know, there is no law that says that an employer has to ever give an employee vacation. But if you do, then it may weigh in on some additional factors. So that's a state law. Short-term and long-term disability are state-run programs, and so that is only spoken to on a state level, as is unemployment, jury duty. Equality in employment is that protected status. So at a federal level, we'll look at this more, they define certain protected statuses. States may add protected statuses. So you do want to check if your state has a law on that as well. Paid sick leave laws are rapidly growing popularity on a state level, protected and or other paid leaves. So because FMLA is only applicable if you have 50 or more, many of the state adopted paid leave laws that are commonly coming into play actually address employers with as few as 5 employees or more, depending on your state. So those are important to keep an eye on. Marijuana in the workplace, both medically and recreationally, and I should say not in the workplace, but on a state level, because that then rolls into the workplace. So far, I'm not going to talk, we're not going to talk extensively about marijuana just because we're limited on time and so forth. But I do want to say this, regardless of whether or not your state has legalized medical and or recreational marijuana, to date, an employer in the private workforce still has the right to regulate and to enforce a zero tolerance of drugs in the workplace. Marijuana is still recognized as a federal one, as a Schedule I federally illegal substance. So I still have the right as a private employer to have a zero tolerance. Marijuana can't be permitted, even if I live in a state where it's recreationally and medically legal. So the other thing is driving laws, in particular cellular usage. Those laws change all the time, and you really have to keep current on what your state law says related to driving. Many states have actually adopted what's called a distraction driving. So anything, and it includes things like putting on makeup while driving is illegal. But you want to find out about that because we have to address driving vehicles and so forth. So cellular usage becomes an issue. All right. These are the overviews to the federal laws that we talked about earlier. And it's meant to give you a very brief overview. So the Fair Labor Standard Act applies to all workplaces in the US that are engaged in interstate commerce. A lot of charitable organizations, religious organizations, think that that doesn't apply to them, but it pretty much applies to everybody because the law defines interstate commerce as, do you have donors that are outside of your state? Do you receive products and services or resources to run your programs or curriculum from outside your state? And if the answer is yes, then that applies as interstate commerce. So it basically affects every single employer in the US. This law defines that the 40-hour work week has to be established. It sets minimum wage. It regulates overtime and other child labor laws. The Fmla applies only to 50 or more employee. Now, they count 50 by head count, okay? The difference is the ACA, Affordable Health Care, they count 50 employees by FTE, and they've defined an FTE, which stands for full-time employee, by their definition, as someone who works 30 hours or more a week.
Now,
FMLA. Oh,
Angie, let me ask you a question on that. What about contractors? Do contractors count towards that 50 total? Or do you
No.
know? Okay,
Nope.
they don't. Okay, so it's
Contractors are not employees.
exempt or non-exempt. So basically any part-time hourly paid, but not contractor.
Right. Any employee who works for you, any minimum hours of week, it doesn't matter. If they're on your roster, they're your head count, right?
Yeah.
So, and that gives them 12 months over, in the last 12 months, they can get up to 12 weeks in a 12-month period of time, provided the employees work for you for at least a year and has worked 1,250 hours in that year. All right, civil rights. This applies to 15 or more employees, so it applies to farm workers. It's the most powerful law prohibiting discrimination in the workplace. I hope I got this one current. I know that I have it on the larger slide. Actually, this one is not as current. Yeah.
Is it this one?
No, it's okay. We'll
Okay.
get to it. Anyway, I'm going to cover that one more carefully on the larger individual slide because that federal law has updated itself a couple times most recently. So I'm going to go down to Patient Protected Affordable Care Act, which is that healthcare one. You just missed it, Andrew. Oh, there it is. Thanks. Sorry. This requires eligible employers to provide employees who work 30 hours or more with access to healthcare coverage. And the healthcare coverage has to be in effect by day 90, not once you work 90 days, then you get healthcare. You have to have healthcare enforced by day 90. Most people don't know that if you are an employer who employs less than 50 FTEs, you're not required by law to provide healthcare. The Americans with Disabilities Act also applies to employers with 15 or more employees. That includes part-time and full-time employees. And again, it just prohibits discrimination based on temporary or permanent disability, physical or mental. You have to make reasonable accommodations. The law is intentionally vague in that because there's a recognition that employers do not all have equality in what is reasonable. So there's some gray area there. The Equal Pay Act basically says it covers all employers who are covered by the Fair Labor Standard Act. So pretty much every employer. And it basically says that if same work, location, same work, same pay, regardless of gender or age, etc. ADEA is age discrimination in employment. This applies if you have 20 or more employees, and it outlaws discrimination in the workplace based on age. It is only applicable if you are 40 years old or older. You don't have a protection under that. And the Older Worker Benefit Protection Act, we talked about that generally. And this one is interesting because it makes me remember to mention this. It applies to all non-union employees in private industry. So interestingly enough, that if you are in a unionized workplace under a collective bargaining agreement, it doesn't apply to you. And collective bargaining agreements often will create some additional factors or overrides to standard applications because those negotiations have occurred within those existing contractors. It's not very common to have a unionized workplace for a nonprofit charitable organization, but it can happen. And yet there's more. Pregnancy discrimination basically says it applies to those if you're 15 or more, but you can't refuse to hire somebody because they're pregnant, and you can't compel them to take maternity leave either. OSHA is the one that regulates safety in the workplace. And it applies to all businesses except self-employed businesses with no employees, farm businesses that only employ immediate family, or businesses such as mining that have their own self-imposed safety and regulatory standards. So, and a BFOQ, like I said, I mentioned that one before. You're permitted to do some discrimination under based on gender or some other thing that otherwise would not be permitted. So. All right, Fair Labor Standard Act. This one I am going to spend a little bit of time on because it affects us all. And this is an area where I see pretty commonly good intention, but bad course of action. So this was originally passed in 1938 as part of the New Deal. And there is no federal exemption for this. It doesn't apply to churches or religious organizations. A lot of people think that because they're filed as a church or a religious organization, that this law doesn't apply to them. It definitely does. Very generally, there's two ways that FLSA can apply. One is by the enterprise or the entire organization. It can also apply to the individuals within the organization, depending on the type of job that they do. So I'm not going to get into that too much because FLSA applies. So
I can move on.
Yeah, sorry about that. All right, classification is a big one and it bears a few minutes of time. In my experience, a lot of nonprofit organizations, because of the nature of how budgets are set up, which is every year a nonprofit organization, especially ministry, puts together what they project their budget will be for the following year. That budget then has to get presented and approved by the board, and then the organization has to work within that approved budget for the year. As a result, what I've seen happen is when it comes to personnel compensation, whatever got approved by the board in the large number then got divided out by the employees per pay period. And it was a relatively common practice that organizations were paying all of their employees on a salaried basis based on what was approved in the budget divided by the number of pay periods. The problem is that's illegal. So federal law defines employees as either exempt, which means they're exempt from overtime. That's literally what that means. It means that those people who meet white collar exemptions as defined by federal law under FLSA get to be paid a salary for the work that they do. All other employees have to be paid for the time that they work by the hour. This area is the most commonly misunderstood and misapplied, and the Department of Labor has estimated that half of all employees in the US are improperly classified. So this is a pretty big deal. The non-exempt, well, I guess I want to say this is the Department of Labor has the ability, if there's a claim made, to go back to an organization, including charitable nonprofits, and to look at your pay records for at least the last 7 years, because you're required to keep them for that long. But they can actually look back further if they want. And if they find that there's an infraction, you can be fined heavily in this regard, including paying people for hours that they would have decided that you maybe missed paying them on.
Angie,
So,
this is worth asking. Have you worked with an organization that's been audited by the Department of Labor?
Yeah.
And I imagine it was painful for them.
It was painful. Yep.
Yeah. Okay. So all these things largely, you know, everyone's always afraid of the IRS audits, but if you're a nonprofit, it's probably going to be more common that you're going to encounter a Department of Labor audit as a potential risk, is my understanding. And there's both state and federal Department of Labors that could come and just show up, and all of a sudden they ask for all your classifications. Is, you know, why this is significant.
Right, right. It is significant. And I will also say that I've worked with ministries, but they all called me after they got contacted by the Department.
Right.
Because honestly, when I go into an organization, this is one of the first things I look at, because it is fixable, it is correctable, and it is something that can take you out. I mean, financially, this is a really not good thing to have. So, okay, moving on. Non-exempt workers, these are most workers in America, they're hourly. The majority of workers fall in this category. They get paid for the time they work. They're required to track and submit their work time, and then they have to be compensated for the time that they worked. So you have to establish a regular work week for the whole organization. That's number 4. So every organization must define their established work week. It has to be the same for the whole organization. You can't have a different one for programs and a different one for the warehouse and a different one for admin. They have to be the same.
So you're
So
saying like Sunday through Saturday is the
right,
definition,
yeah.
or
So
yeah.
Sunday at
Okay.
midnight through Saturday at 11:59, there's your established work week. That is how you track 40 hours within an established work week. Any employee who works more than 40 in that established work week, who is a non-exempt hourly employee, you by law must pay them 1.5 times their rate, the regular rate, for any time worked over 40 in the established work week. I will say California, if you're out there from California, has its own state law, and they require, in addition to the 40-hour work week, overtime for anything over 8 hours in a given day. So you want to check your state to see if there's any additional laws, but this is the federal law and this applies most commonly. When you're calculating overtime hours, you only count actual time worked. People get confused and they say, hey, I worked 48 hours in this pay period. How come I'm only getting 48 hours of straight pay and no overtime? Well, 8 of those hours were sick time. So the hours actually worked were 40. Therefore, the 8 of sick is not work time, and therefore it's not compensated at 1.5 times. Does that make sense?
Yeah, that's good to know.
Okay, it's important to know. People give away money. So you may put non-exempt employees on a salary. I get this question all the time. Hey, at my last job, I was a salaried employee. Well, there's probably 2 reasons. One, they did it wrong. It happens all the time. Or you can put a non-exempt employee on a salary, but they still are required to track and submit the time they worked. And if they work over 40, you have to pay them for overtime. Now, I don't know about you, that sounds like extra work for me when it comes to payroll. It doesn't really make sense. I think if you are non-exempt hourly, just run it that way. And if you meet the salary for exemption and you're exempt, then run it that way. Number 7 is critical. It is illegal for an employee to volunteer to work overtime in the same department that they work or in a related area. Okay, I'm gonna say that again, because in missions and a lot of nonprofits, people say, I don't want the overtime. I just want to work extra because that's how I can give back. It's illegal. Okay, so Thanksgiving meal, right? Everyone, we're gonna feed the homeless, and it takes extra volunteers. Anyone who works in food services cannot volunteer to work for free or overtime without payment in that area because it's their area. If I process donations and I want to volunteer to serve a meal, I can do it. But anything within the same department is illegal. All right, exempt workers. There are 5 categories and then the highly compensated that are defined for who meets the criteria to be what's called a white collar exempt worker. That's a category. Okay. First of all, exempt workers get paid to get a job done. They do not get paid for the amount of time it takes them to get the job done. So you do not ever want to pay an exempt worker based on the time that's put in. They get paid to get the job done. There are federal definitions, and some states have added definitions. The ones I know off the top of my head, because I don't have all 50 states memorized, but I believe Washington state does, I know New York state does, and I know that California does. There are probably some others, but you may want to check into that. The first, so we will actually, I think, look at these, Andrew. Will you go to the next slide? That way I don't see stuff twice. Yeah, I'll get there. All right, so there are 3 tests. In addition to meeting one of the categories, there are 3 other things, well, 2 other things. Excuse me, quick sneeze. No droplets, no Rona, we're good. Okay, salary level. This increase actually just went into effect January 1st of this year, 2020. And it says that the new minimum salary that an exempt employee can make is $35,568 annually, or $684 per week. And that is free and clear. You cannot include room or board or anything else with that. That is wages. The salary basis is also means that they have to regularly receive the predetermined amount of money of compensation without fluctuation due to quality or quantity of work. So if you set an exempt level salary at $700 a week, and on Tuesday they were out sick, you can't dock their pay. Even if they don't have sick time, you can't dock their pay. You have to pay them the same consistent salary. There's very few acceptable reasons for docking an exempt person's pay. So they basically get the same amount of money. And then the duties are specific to the type of exemption that they meet. All right.
So an organization would need to meet all 3 of these for each position for it to be classified as exemption.
Yes.
Okay.
So we're going to talk about the types of exemptions. One is executive. Essentially, executive employees are those whose primary job is to manage the business of the business. They tend to be in charge of departments. They're the C-level, the VPs, the executive directors. They're over departments, et cetera. They have to supervise a minimum of 80 hours of employee time on a weekly basis. It can be 2 full-time, it can be 3 or more part-time, but it must be a minimum of 80 hours and it must be employees. It cannot be volunteers. It cannot be participants or residents or interns. It's gotta be employees. They also have the authority to hire and fire. The second one is administrative, and this is the one that I think is most commonly misunderstood. It does not mean administrative assistants, okay? It means administrative employees. Their primary duties are performing office or non-manual work on matters of significance relating to the management of the business or the business operations or its customers, and that require the exercise of discretion and independent judgment. Now, you can do your research and read up because they pretty much provide definition around most of those terms and phrases. Essentially, what it means is I have the ability to make decisions without running everything up the flagpole for approval. I am empowered to act and to make decisions that have an effect on the organization without getting it approved by someone else. These tend to be department heads who may not have the supervision of employees like an executive would, but they are the only administrative exempt position that is an administrative assistant position could be the CEO's executive assistant. And even then, only if that person has calendar management responsibilities, control over the schedule of the CEO. It's very prescribed. A professional exemption actually has a subsection that's a creative. And so we're going to talk about both these. But a professional exemption is an employee who primarily performs work requiring advanced knowledge or education and includes consistent exercise of discretion and independent judgment. So essentially you have to, the advanced knowledge really is in a field of science or learning acquired in a prolonged course of specialized intellectual instruction. Typically, the bare minimum is a bachelor's degree and you have to be working in that field. So if I have a degree in art appreciation and I'm in HR, that's not a related field. I'm not using my prescribed trained education in my current vocation. Okay. Go back because we missed professional. We need that one. Thanks. The creative professionals perform work, and this is newer. This law was updated in 2004, and that was a really significant update because it kind of released a lot of professions that were common in America 50 years before, like bricklayers, and it moved into marketing professionals. And so it accounts for a creative professional has to perform work that requires invention, imagination, originality, or talent in a field of artistic endeavor. It includes web designers, website managers, writers. It can include marketing professionals. So there's a list that is inclusive that you can take a look at. A computer exemption is not the computer help desk person. It is someone that functions at an analyst or programmer level. And then the last one is highly compensated. The highly compensated exemption means that if someone makes at least $107,432 a year, of which at least $684 is paid weekly, because in this kind of scenario, it permits bonuses as part of the total comp. But you have to make at least that much money a year, and you have to fulfill one of the other duties of the white collar exemptions. That person can also be exempt. The exemption that I did not mention, because it's seldom used in an nonprofit organizational setting, but given that you guys may be in some other workplace environment, an outside salesperson who works on commission, has a base plus a commission, can be set as an exempt employee as well, so long as the total comp equals the minimum of federal and/or annually week paid. All right, so common questions that are related to wage and pay. Do I have to have all employees record their hours? No, by law you don't. You have to have all non-exempt employees record their hours. Many organizations have exempt employees track their hours for purposes of planning and accountability. It helps an organization know if an exempt employee is overloaded, if they're constantly working 60 or 70 hours a week. So you don't have to have all your employees record your hours, and you absolutely do not want your exempt employees to track and record and submit their hours for payroll. That's not what they do. Do I have to use a time clock? No. The law requires that non-exempt employees track their time. It does not require that they track it in a certain way or all the same way. You can use hand time sheets, you can use computerized or apps on your phone, but you've got to do it for all non-exempt employees. What about changing time that's already been recorded? You've got to really put a tight regulation and policy around this. Pay records are legal documents, and organizations are required to keep those for a period of time. So if an employee, and this happens all the time, forgets to clock out, they need to send an email really to HR, who tends to have administrative privileges, and/or to their boss, their manager, and say, I forgot to clock out. I stopped working at 4:45. Would you please make that change to my time record? That's fine. But you really want to get in the habit of having employees make that request in a manner that is documentable, that can support the change of the record. What if my employees don't want to be paid overtime? We don't have a choice. We have to pay them overtime. They can donate that money back if they want to the organization. There's nothing wrong with that. But the law does not give an employer the option to just not pay the overtime. You have to. 5, can I have different established work weeks for different employees? No, you've got to have the same one for the whole organization. What about comp time? Okay, sit down for this because no one ever likes to learn this. Comp time is illegal in the private sector. It is fully legal in the government sector, but it is illegal in the private sector. So comp time, which is Compensatory, I'm sorry, I'm like getting these all mixed. I'm saying compensable and compensatory. Comp time means in lieu of pay, I'm going to get time, but you can't do that legally in the private sector. So what you can do is say this week I had to pay somebody 4 hours of overtime. Okay, 4 hours of overtime is equal to 6 additional hours at straight pay. If I need to maintain budgetary compliance and it works within the organization, I can adjust that employee's work the following week to reduce the 40-hour work week to a 34-hour work week, because I'm going to give them the equivalent of what I've got to pay in overtime, which is the 6 hours in time off. Sometimes that works and sometimes it doesn't.
Now,
But,
Angie, let me ask you about comp time. So some organizations will use, and they'll call it comp time for an exempt employee that say, you know, they use monthly pay and someone works, you know, 50 hours in 1 week, and then the next week they work 30 hours. And is that just not called comp time? Is there a problem with doing something like that?
I don't even think I understand the question.
So you have an exempt employee, and then you have some sort of, you know, say it's Thanksgiving and it's a really busy, you know, week that week. So they work 60 hours,
Okay.
but the following week within the same pay period, the employee just says, you know, you can chill more this week and, you know, not come in for a day.
Yeah.
That seems pretty common. I mean, I see this in a lot of organizations, but is that, how does that fall into what you said on point 6?
Yeah, that's not comp time. I know that that's commonly called that, but comp time is not even relevant to an exempt employee. You've got to go back to this. Exempt employees are not paid for how much they work. They're paid to get a job done. So there's a lot of subjectivity within that definition.
What would you have them call that? So that
It's flexible time.
flexible time. Okay.
Yeah.
All right. That's good to know. Okay. Sorry.
Yeah.
So you can move on to 7 if you want.
Okay. 7, the same employee has 2 different part-time jobs at the same organization. The law would view that if they are, well, first of all, that's a non-exempt hourly employee, okay? Because they have 2 different part-time jobs. Those are basically all going to be hourly jobs. They still count collectively toward overtime. If they're both for the same organization, you don't get 40 hours in each position before you're subject to overtime. It's the combination of the 2. If they do 2 different jobs that pay 2 different wages and you get to overtime, then there is something that's called a weighted differential that you would have to pay them, kind of the weighted differential average of those 2 jobs in the overtime amount. So that is something that I get asked fairly regularly.
Okay. I have 2 more questions for you in
Sure.
this. So one is, do you see if organizations have policies that will say you're not allowed to work overtime without getting clearance, so that employees don't just all of a sudden, you know, I work 9 hours that day.
Yeah.
Is that fairly common?
Yes, it is fairly common that it says that overtime must be pre-authorized. However, even if it's not pre-authorized, an employer has to pay it. You can't not pay overtime, even if an employee violates your policy. You can discipline your employer for violating your policy, but you cannot withhold overtime.
Okay. All right. And then the other question, what was it? Oh man. Hold on. I'll think of it in a minute and then I'll share it with you.
Okay.
Okay.
Employment at will. Employment at will operates in 49 out of 50 states, and the only one that doesn't is Montana. Montana is you can only release somebody from employment for cause. At will means that either the employer or the employee may end the relationship with or without cause or notice. It does not grant an employer a blank check to just fire an employee anytime they want. You have to be pretty careful about it, because if there's actually other reasons at play, but you just say, yeah, we're going to let you go for at will because we can, that's really not the right application. Most commonly, employment at will is best used in the introductory period of employment in the first 6 months, because that is the time period where both the employer and the employee should be ascertaining if this is a good fit, if both made a good decision in deciding to work together. So if during that time you're not thinking that it's going to work out, that is really the best time to separate under at-will employment, because it's not working out. It's not a right fit. No harm, no foul. You're just going to end the employment. So.
Yeah, I remembered what I was going to ask
Okay.
on the previous section. So from what I remember, I think we were under A133 audits if you deal with government money. And if you have some sort of A133 audit, and I think other states will have this as far as their requirements, they can require some sort of timesheet for salaried employees or some way to indicate that how their hours are being allocated as a part of that. So I think that's something that just to be aware of. You may be in a state where even exempt employees, you need to have them, have some sort of way of allocating their hours.
That sounds like a grant provision.
Yeah, in grant
Yeah.
provisions often tie back to A133, but I'm pretty sure that's a standard in A133. But
Okay.
yeah, so was there anything else on this unemployment at will?
Nope, we got it.
Yeah, I mean, as I understand unemployment at will, part of it is it also, and tell me if I'm wrong, but it also protects you from employees assuming that there's like, the alternative would be to have a contract, like you're going to be employed for a year, and if you fire them in month 1 of that year, then you got to pay the other 11 months if you had a contract, essentially.
Right. Right.
So that's a significant part of the at will. But I think your main point, and we have an article this week, is that at will doesn't mean that it's like a no fault divorce, like you can just get rid of the person for any reason. You're saying that there could be liabilities if you're negligent, and how you do that essentially is
correct. Yeah.
Okay.
All right, the Affordable Care Act, which is actually called the Patient Protected Affordable Care Act in its full name. But again, this applies to employers that have 50 or more FTEs, and this law defined a full-time employee for purposes of eligibility under the law for someone who works 30 or more hours a week. It requires that eligible employees are enrolled in health care by day 90. They have to be offered affordable health care for the employee plus the dependents. The interesting thing is that affordable health care does not apply to the spouse component. And affordable is defined essentially, and they just updated it. It's slightly higher than 9.5%. It's about 9.85, I think, right now. It says that if I offer a healthcare plan, then what the employee is required to pay in their premium shares can't exceed 9.5% of their total household income. Otherwise, it's not affordable. The kicker is, as an employer, I can't ask for their household income. I have to guess at their household income based on what I know. So we're not going to get too far in the weeds on that, but essentially that's the regulatory definition around affordable health care. It only applies, again, if you have 50 or more FTEs. Organizations that are smaller are not required under law to provide health care, and they don't, even if they choose to do it, they don't have to provide it to people who work 30 hours or more. They can decide to provide it to their definition of full-time employee, which might be 38 hours or more a week. So there's a lot more latitude. In the event that you're unsure or you ever need to know how many employees are at your organization to know if you're subject to ACA, there's a website under G that is the healthcare.gov, and there is a FTE calculator where you can input the information and it will tell you how many you have. Civil Rights Title VII. This is the biggie, and it's the one that's probably had more news as of late. So this is the one, again, that the federal law that talks about discrimination and employment. Under Title VII, it talks about related to work. An employer may not discriminate with regard to hiring, terms and conditions, or privileges of employment. And it affects recruitment, hiring, promotion, transfer, training, disciplining, essentially the whole employer-employee relationship. Many charitable organizations get confused here because they think that this same Title VII of the Civil Rights Act applies to also who they give services to. And that is a different section of the Act. It does not apply to that. Title VII applies to who we hire. Okay, that's what it applies to. The federal law is race, color, religion, and sex. And sex was recently expanded under the Supreme Court to include, it has included pregnancy. It now includes sexual orientation and gender identity. National origin is protected, age if you're 40 and over, disability, and genetic information, including family medical history. This is the federal list of protected statuses. States tend to add other things, and they add all kinds of interesting things. So you definitely want to check out what your state says. The Civil Rights Act, Title VII, if you are a religious organization, then there are some protections that may be yours under the Civil Rights Title VII. There's three main things I want to talk about. One is the organizational religious exemption. This grants an organization, the whole organization, which is formed and filed, formed as a 501c3 charitable religious organization and filed with the IRS and with state as a 501c3 charitable religious organization. If you are filed and formed in such a way that you exist based around a religious purpose, then you have the right to hire individuals, or to prefer in hiring individuals only those who share your same faith, beliefs, and convictions. So if you think about it, say the organization Jews for Jesus, they have the right, because their entire basis for existence is to witness and to share that for Jewish people, there is the ability to come into relationship with a savior. They can choose to hire people of Jewish beliefs as opposed to Presbyterian beliefs, for example, because they believe it to be core and foundational to their organization. Rescue missions, we can hire people, Christian organizations that are Christian ministries, you can hire other Christians, people who articulate that they have a personal relationship with Jesus Christ. Synagogues have the right to hire only people who are of Jewish faith. Mosques they have the ability to hire only people who are of the Muslim faith. So that's essentially the organizational religious exemption. It means that the organization believes that in order for the organization to maintain its intent and purpose and to fulfill its purpose, they need to hire people who have the same faith basis, because that faith is foundational. The BFOQ applies to a position rather than an organization. So some common examples would be a house parent in a center for women and children. I could hire a female. A clothing designer hiring models. If I design men's clothing, then I can only hire male models if I choose to do so, because I'm trying to sell to men. If I'm going to hire an actor to portray Nelson Mandela, I have the right to hire a male African American. I'm not going to be forced to hire a female or someone of a different ethnicity. Those would be legitimate based on the position. A ministerial exception has gotten recent attention. It's been around for quite a long time. And for years, a ministerial exception basically meant that certain religious organizations hired people who fulfilled ministerial functions within the organization. Their job was to educate, evangelize, advance the religious component of that organization. And most commonly, a person who fulfilled a ministerial exception was held out to others as a minister within that religious organization and had some licensure, some specific religious training that enabled them to have that religious exception. The recent Supreme Court decision expanded that ruling the ruling expanded the definition, and it's not such a hard and fast list. What they're saying is that a religious organization can really view almost anyone, if they hire someone of the same faith conviction, as a minister of that organization, so long as their key and primary core responsibilities include teaching about the religious aspects of the organization, preaching, leading Bible studies, anything that is held out to be core to the religion of the organization. Primarily, the ministerial exception pertains to the inability for the employee to bring suit against the employer related to the Civil Rights Act. It is literally, that's where the courts separate church and state, and that an employee who is considered to be a minister does not have the right then to bring suit for discrimination.
Yeah. And let me just expand on this, Andy, because I've done a really deep dive, years of, going through this. And some key points, and I think we have some links this week that you can look at that go a little deeper on this point. But on the organizational religious exemption, one key thing is that you make it clear everywhere in your organization that you're religious. So there have been organizations that way in the background, it was, in their bylaws, it was religious, but it wasn't clear in their website. It wasn't clear anywhere else in their annual report. Right. And they ran into problems. Similar thing in job descriptions on the ministerial exemption, that usually it gets tied to the job description. So one of the principles there is that you have something in an employee's job description that's legitimate, that somehow ties to faith. So I've seen organizations, I think World Vision said, ability to lead a Bible study among other staff, that becomes a part of that ministerial exemption. And Protestants, the whole thing behind Martin Luther was that we are all ministers. It's, what's the phrase, the democracy of the priesthood, or I forget what it is, but we're all priests. And so it kind of is an affront to all Protestants to say the only people who are ministers are those who have an MDiv degree, right? So I think that's part of why the Supreme Court, but the reality is we don't want to make that so that, any organization can discriminate for any reason. But if your organization, and I think in the Supreme Court case, wasn't it teachers that were teaching in a Christian school, and even if they weren't just teaching Bible classes, they were often integrating faith, and that is a part of the job description. So if you're a faith-based organization, you're going to use this, do your homework, because that's important. So,
and we address this in greater detail
okay,
specific to that as well, because that's so essential right now. So,
okay, great.
The other things that have come out of the Civil Rights Act is the EEOC, the Equal Employment Opportunity Commission, which is the enforcement agency to make sure that there's equity in employment. Harassment and discrimination is defined under the Civil Rights Act. It also not only defines what illegal harassment and discrimination is in the workplace, but it also regulates training. It establishes policies, and it mandates certain action. The EEOC is the federal entity that would take action if there's found to be a claim of harassment or discrimination in the workplace. And more, there are now laws, both state laws, that require certain private employers to provide training to their employees on an annual or biannual basis related to anti-harassment and discrimination. So that would be another thing that's important to check your state law. The other thing that it includes under the civil rights is that there can be no retaliation or non-retaliation from an employer if an employee brings forth a concern or a complaint related to harassment or discrimination. So even if it's an unfounded complaint, Until that has been fully resolved, you cannot in any way take any retaliatory behavior toward an employee, or you actually then have violated the law. So, employee handbooks, we're going to talk about this now. If you go to court, you got to know that that handbook is going to go with you. And not only if you go to court, I'm going to say it this way, if you get sued, if there's any kind of legal issue that comes up, the first thing that your employer, that your lawyer is going to ask for, and usually the other side's lawyer is going to be your handbook, because that contains your policies that you have put out there to your employees. So this is a really critical handbook. The handbooks are very critical. They've honestly got to be reviewed and updated every couple of years because there's so many legislative changes. Additionally, an organization maybe has 15 employees right now, but 2 years later they could have 27 employees, and that alone will change the certain compliance issues. So it's really important to have that. If you have 3 or more employees, you need a handbook of some sort. It'll be smaller than the bigger organizations, but you still need one. Ideally, employee handbook should reduce liability. It should communicate expectations and standards and provide guidance for your employees. Look, I write these a lot, and I have no illusions that people are super excited to get their handbook and they read it cover to cover. Okay, that never happens. People will pick it up and look for stuff when they need to find specific information, when they want to know what their latitudes are, or their options, or their limitations, or their entitlements. That's when they'll pick it up and look at it. But nonetheless, you have got to be, this has to be a super important book for you. When you're writing a handbook, there's a couple things I will definitely point out and say. One is beware of absolutes. You really want to avoid using finite conclusive words, will, always, and never. You know, you just don't want to put yourself into a corner of having no alternative but one alternative. Second is you want to be very mindful of outdated, inapplicable, or inaccurate information. Handbooks, like I said, have to be reviewed and updated every 2 years. And one of the practical things you can do is keep a copy of your handbook handy in hard copy or whatever, and make notes. As you go through and actually interface in the workplace, you will find that what you thought was a clear policy was not very clear because an employee completely misunderstood it, and you want to make a note so that in the update you can make it more clear. Or you may find out that your state recently passed a law that now requires you to give 72 hours of sick time every year to full-time employees. Well, you're going to want to make that note too, because you've got to include that in the handbook. The third thing is you can't assume that employees know. It's really important that when you do an update that you roll out that handbook, that you send out a note. I'm a huge fan of posting the handbook in PDF, by the way, somewhere electronically where employees can access it. And when you do have an update, you can just send out a general employee notice that says, hey, I just wanted you to know that we've updated the vacation policy. You can find those updates on the electronic version of the employee handbook located here, and it's on page 49. Okay, so you want to be really proactive about your handbook and any updates. When employees are first hired, I really suggest that you offer a couple opportunities for Q&A related to the handbook and associated policies. And even maybe once or twice a year, have an open opportunity for any employee to come and to have a Q&A over handbook stuff. What's funny is sometimes employees will be promoted into a position of management or supervisorial responsibility. And all of a sudden, they have to interact with those policies because now they're directly supervising employees, and they need to know more information at that point, and they need to have a better command of the policies that are inclusive. So I think that it's important to really incorporate that into your onboarding, but to make it periodically available to all employees anyway. In every handbook, you want to make sure that they have signed a statement of understanding. They've been given a handbook, they've read the handbook, they've had a chance to ask questions. And if they have questions in the future, they are welcome to ask them, but they have read it and they agree to abide by it. Okay.
Yeah, I think that's a really important point, because otherwise a lot of the legal protections that come with a handbook don't apply because
Right.
you can't say, oh, in our case, and maybe we should have a separate statement. It's actually in the handbook where he says, I understand that employment's at will, and they sign that. So if we
Oh,
didn't have
yeah.
them sign that, then we wouldn't have that. I have a question on the handbook. What do you recommend for organizations on where is the authority to make the decision for changes? Is that usually at the executive director level, or is that at the board level? Like, do you view this as
Oh,
policies, or what, and is that defined in the handbook usually?
well, first of all, it'll depend on the nature of the board. If your board is an operational or a management board, then they're going to have a lot more say in the daily operations of policies in the handbook. If your board is a governance board, then they really shouldn't be involved in the day-to-day management policies. But they would be involved in a couple, such as a conflict of interest. That would be a pretty common, because that's an
Yeah,
organizational affect, or a whistleblower policy, a couple of those. But
right.
in terms of the general nuts and bolts of the handbook, they may not be down in the nitty gritty. However, especially when there's a major overhaul or a major rewrite, in most cases, there is a board approval of the overall handbook because there's been significant change or update. And at that point, really the CEO is the final authority in terms of policy change, et cetera.
So basically what I hear you saying is boards, just things that are going to be major legal issues that are required for boards to essentially have, like, those policies that you mentioned. And then in most cases, you're seeing that the CEO basically has to sign off on changes to the personnel or the employee handbook. Um, I,
Most
I,
of the
I
time.
assume otherwise, I mean, assuming HR is in line, but you could have HR add a benefit and the CEO is not aware or something that,
Yeah,
that could be
no,
problematic, right?
right.
So,
And to be honest, when you think about it, if it is set up that way and you're in charge of HR, you need to request that that be changed. That is an inequitable check and balance system there. You
right,
never want, yeah, an individual who's not really an officer of the company to have that level of responsibility, because it puts you awful far out on a limb and it doesn't make sense.
right.
So,
Yeah. I mean,
yeah,
at least the organizations of the size that I've worked in, I would always want to be the one signing off, just because
yeah,
the risk of legal liability, and you could put things in there that could significantly affect your budget. So, okay, that's
yep.
helpful.
Okay. So the other thing is in writing a handbook, it's got to be specific to your organization. Um, so often I see, especially nonprofit organizations, Christian ministries, sharing handbooks. Don't do that for a couple reasons. One is, again, going back to the type of organization you are and the number of employees you are directly affects the things that are applicable to you. The other big thing is the state that you reside in. So if you borrow the handbook from another rescue mission who's in another state, I'm going to just say it, you are going to end up including things that don't apply to you and end up missing things that do apply to you. You cannot just use a standard template on this. On the flip side, a lot of payroll services provide their clients a standard handbook template. But if you are a religious charitable ministry organization, understand that their standard template will be for a public or private employer. It's not going to be for a nonprofit, and it's really not going to be for a religious nonprofit. So again, you've got to my suggestion is templates are not great. Borrowing
Yeah.
from another organization, not great. And I've had a few different organizations call me, religious organizations call me and say, hey, we just finished writing our handbook. We started with this template. Could you review it? And I feel terrible, but I basically have pulled apart 65 or 70% of it because it doesn't apply. It doesn't make sense. It's either inaccurate or it sounds very clinical, which is completely contrary to who the organization is as a whole. And it's almost like an entire rewrite. So you really have to make it specific to your organization.
Yeah, and Angie, I know a part of your consulting you do is to help organizations write their employee manuals often.
Often.
And, um, you know,
Yeah.
whenever I was first doing ours, I mean, we didn't have the money for a consultant to do that. So, part of it is, what do you do if you're like super small and you don't have money for a consultant or a lawyer? One, that kind of puts you in a bad spot, right? But part of what we did, and I can just give advice for smaller organizations, is you got to recognize the different categories of bases you want to get covered. So in our case, we were a national nonprofit. So we looked at what World Vision was using. We then also looked at a local Christian nonprofit that was very large. In both cases, we went to large organizations because they're going to have better manuals. And you actually gave me something else that would have been helpful, because just because an organization has, $5 million budget and it's local, doesn't mean that their manual is going to be correct on everything. Probably the third thing that I would have done is look at a something from our payroll vendor, because they probably will be up to date, on the state. And then at that point, you're your own lawyer and you got to cover all your bases, which is not an ideal situation to be in. But, half our organization or half our students are in organizations that maybe have, 20 employees or less. So, they're going to be in a challenging situation. So that's what I would recommend is, and then, especially what you don't want to do is create a 100-page document that you haven't read, because you're basically creating a contract that has a bunch of stuff you don't understand and, is really problematic. So, and I think part of Andy's point is that, you know, it might save you more money in the long run to pay for someone who's gonna, to help you sort through that. So you don't have to, I mean, an example might be you borrow from an organization in California that has tons of regulations, and then all of a sudden you put a bunch of things that you don't need and you end up paying for them that you don't really need. So,
Yeah.
yeah.
Yeah, because if you put it in there, and I've seen that, FMLA, for whatever reason they borrowed it, company under 50, they put an FMLA, guess what? You're going to start giving FMLA leave because it's in
Right.
your handbook and you say that you do, even though you don't have a legal responsibility to do it. So it is true. And I do consult on this and I do help people write it, but I also review. So if you're not sure and you want to take a pass at it first and then get it reviewed and say, hey, you're missing this, you need this, you don't need this, you got this. That is something that's under $1,000 to get done. It's like $500. It's not an expensive thing. To even write a whole handbook usually is a couple thousand. And so all I'm saying is I know it's not cheap, but that's a couple hours with an attorney.
Right. Yeah.
So
Yeah.
my point is, yeah, just do all the legwork you can up front and then get someone who actually knows what they're doing to minimally review it for you. It will save you a ton of time in the back end.
Right.
Uh,
And
and I've
and
had
part of the reason why I was willing to do it, I've taken law courses, and I, you know, I know how to do some of this stuff. I'm not a lawyer. I'm not in your situation, Angie, but I had some expertise. But I think the point is recognize when you're out of your, you're doing something that's above your pay grade, and you need to bring in the experts for those type of things. So, yeah.
Yeah, and time is money. I mean, I've had executive directors go, okay, I thought I could do this on my own. I can't believe how much time it's taking me to even figure out, what end is up. And so, yeah, take a look at all those things. The
Yeah.
other thing I'm going to say is that if you do it, you don't want it to sound different than who you are. So the one other thing is, if you're going to borrow or use a template at all, is there's so much hardcore legal language, stuff like violation of this policy may result in disciplinary action up to and including separate, dismissal. Well, you don't want to say that after every single policy. You guys sound like you're hardcore police. So there's those kinds of things that you need to figure out how to soften. The other thing I want to say is, and I know this sounds really fundamental, but I'm forever shocked at how this doesn't get incorporated. You need a table of contents. You can't just write a bunch of policies and put them all in there. And I have seen people organized by alphabetical order of the name of the policy, which quite frankly is a mess because there's no rhyme and reason. You don't have employment administration with benefits, with time off. They're all just mixed in there together, and employees can't find anything. So really, really think about how you organize your employee handbook too.
Yeah, I mean, one thing I would say is even if I worked with a consultant or an organization worked with a consultant, I would highly recommend that the executive director be very involved in that process, because the other thing I've seen,
Yes.
and honestly, I've seen this be a bigger problem than having a bad manual. It's having the leadership not know what's in the manual and not follow it, for small organizations. So,
Yeah, yeah,
you could have the correct manual. It's kind of like the people who read the Bible and don't do it. You could have the correct manual, but if you're not doing it, you're going to be in even worse trouble.
yeah.
So, yeah.
To your point, yes, they should be involved up front. And the other thing that is completing an employee handbook is once it's done, you have to do an all-staff rollout. It is really important when you get that handbook written that you have a session for supervisorial employees and higher so that they understand the interplay and their responsibilities over and above a standard employee. And then you do a rollout with the whole with all employees, the whole staff. Because to Andrew's point, it says we've invested in this. These are the standards. We're communicating the policies and we're all subject to them. And it's critical because in fact, you will be in a worse legal position if you go to the trouble to write a handbook and then disregard it or pick and choose when you're going to follow it.
Yeah. And one of the assignments that we have students do is to read your manual and to provide recommendations. Part of the reason why we do this is part of the intent of this course is to help people become managers. We have nonprofit management degree, we have ministry management. So this is about helping you be a manager. And if you don't know your employee handbook really well, then you're not going to be a very good manager because you're going to get yourself in legal trouble. So I think that's an important point. And if anyone ever does want to work with Angie, we have her contact information, in the presentations and on the YouTube links and various places. So, and I know this next one, you kind of have sample contents.
Yep.
We also do have some sample employee handbooks that you can look at. I think this is actually probably more inclusive than even the samples that we're providing. But this kind of looks like a checklist, Angie, that you would use to see, do each of these things apply to this organization and are they covering it? Is that kind of how you use this?
Yeah, pretty much. You will note like FMLA over in the third one, it definitely says
Right.
50 or plus employees.
Yeah.
So some of those things will have some parameters, but yeah, there's most of these things, if not all of these things, need to be checked to see if there is applicable law for you. Like crime victim leave is a growing number of state laws. It's the very last one on the third column. And there's some protections around that. But if your state doesn't have it, then you don't need to include that. But you need to check at this point for all of these and include most of them.
Okay.
All right, ways to reduce liability. Well, clearly communicate who you are and why you do what you do. We've been pretty much saying that, and in this handbook, it's no different. And as Andrew said, it's across the board. It's in how you post your job advertisements. It's in your website and how to apply for employment. It's on your application. It's in the questions. It's in the questionnaire. It's in interviewing. It's on the job description. If you are a religious organization, that needs to be unmissable. The other thing is consistency. Organizations that are inconsistent in their communications, interactions, decision-making, and policy application create huge liability. That is, if you think about it, the definition of discrimination. It's inequitable treatment. So you've got to be super clear and mindful that you are consistent. In fact, one thing I say a lot to clients that I work with is that when you have to make a decision regarding an employment related decision and it's not regulated by law, you need to understand that the decision you make sets precedents within your organization and will serve as kind of a tile for reference for future same situations. So you've got to be really mindful of the consistency and of the decision making that goes in. The other way to reduce liability is keeping your policies current, legally compliant, and actually abiding by them, to provide training and coaching to supervisorial employees, and to document. If you have a situation where you may make an exception, you need to document why. And you don't want to make that commonplace, but it does occur. I'm not going to say that everything is always handled the identically same way. If I have an employee who steals a food box and has worked for me for 8 months versus an employee who steals a food box and has worked for me for 8 years and has a really great track record for 8 years, there's a good chance that how I handle that situation with those two different employees will look slightly different. But I need to document the reason behind that and not just leave it at they both did something and they were handled differently. There were reasons why they were, and that has to be part of the documentation. Again, for Christian employers, you've got to make it unmissable that you're a Christian organization. And I list all the places where. Just a reminder, don't overstep your rights. Just because you may have an organizational religious exemption in hiring does not mean you then get to overstep other protected statuses. In no way will it be upheld if you think only men should be in leadership positions, okay? Never gonna happen. And if you do have an organizational exemption, religious exemption, and you don't choose to use it, you could lose it, or you minimally would compromise the strength of your defense if you ever get challenged on it. So what I mean by that is if you have an organizational religious exemption and you say, we only hire Christians in employment because every single position is core to making sure that we honor who we are and we fulfill our purpose. And then down the road, you decide that you really want to hire this person who's not a Christian, but a really good person, but you want to hire them anyway. So you do. And you say, it doesn't really matter if they're a Christian or not, if they want to work in the learning center, for example, because that's all academic. It's not even really, Christian. So that employee goes to work for you and puts Buddha on his desk, for example. As a Christian organization, you're going to have a real hard time defending that you're requiring that person to remove that because that is their religious expression. And in this hiring, you have foregone your organizational religious exemption and now moved into a position specific, which is more BFOQ. So it becomes weakened from a position of defense if you get challenged in, you don't really have to be a Christian to work here. It only matters in certain positions.
Okay. Yeah, these are all really important points. I've seen so many organizations get burned on this. And,
Yeah.
if you communicate clearly, throughout everywhere. I mean, the example I say, if someone's walking into a church, they should know they're walking into a church and not be surprised. They shouldn't walk in and think they've walked into a 7-Eleven and then all of a sudden it's a church, So, and that applies to all these things, your application, your job posting, your interview process, your hiring documents, employee handbook, like all those things I think are important. And what do you do if an employee leaves the faith? You got to, there's going to be things like that you have to be able to address. That's kind of the operational decision of, and if people have questions of faith, that's one thing. But, if you have an employee that all of a sudden, you hired them, they were a Christian, then they just became a Muslim, that becomes complicated, but you still have to be able to, and there's protections for this because essentially what they're recognizing is there aren't just individual rights, there's collective rights and there's religious rights, and often religious rights relate to the community that is a collective right. So.
Yep.
All right.
Intentional and critical infrastructure is a religious organization. One is your corporate documents, how you're formed and filed, and your purpose of existence. Those are really going to set the tone much of the time for how it is that you carry out and make decisions related to hiring and exercising latitudes that may be yours. Your employment documents and materials promote self-screening. They should all promote self-screening so that people who don't share your same faith alignment go, yeah, this isn't the place for me. That's a great place to be. No one wastes time, very simply put. You want to be consistent in the application of the standards that you apply, and you need to continually educate people who are both applying to your organization and who are within your organization as to where those boundaries are and what they look like practically. You just mentioned this, Andrew, basically. Yeah. This is World Vision was getting sued at some point, 2009 or 10. and it was 2010 was the final outcome. They went before the Ninth Circuit Court, and they were being sued by 3 employees or former employees who were released because they departed from the faith, and they were very vocal about that. And in specific, they said that they no longer believed that the Trinity was an actual thing, that it wasn't applicable. So they sued World Vision because they said World Vision was a relief organization who happened to also have a religious component. World Vision said, no, we are a religious organization, a Christian organization, and we fulfill our beliefs through social relief programs and services. They ultimately won. Most critical reason why they won is that it was unmissable. You could not go to work for World Vision and not know that they were a primarily religious organization. And so just to your point, when someone does depart from that, if you have done your job right, good, and well to separate, you don't have to denigrate, you don't have to pass judgment, but to separate because you no longer have a shared belief system. And that shared belief system is essential and core to who you are as an organization. That is a permitted legal decision, provided you've done everything right.
Yeah, and I actually talked with the chief legal counsel at World Vision multiple times, several times over the years. There was a period whenever we took government funding, and if you do take government funding, part of what you have to do is recognize that some of these principles may or may not apply to you, depending on what the government funding. There are some agencies like the Corporation for National and Community Service with AmeriCorps and Vista, they do not allow for religious exemption and hiring. And that's part of the reason why we actually left, was because of that. There's other agencies where it is still protected, but it creates more challenge. Part of the reason why World Vision, I think, has been a particular target is because they do take especially USAID funding for their global relief efforts, and people have targeted them, for that in other ways. I don't think it was this particular lawsuit, but that's something just to be aware of. If you ever do take, whether local, state, or federal funding, there can be different rules, and just recognize that you may be signing up for potential lawsuits. That's part of why we just got out of that business. Was World Vision, I don't know how much they spent on this, but my guess they probably spent $5 to $10 million on this lawsuit, so they could afford to do that. If we had to spend $5 to $10 million on a lawsuit, we'd be shut down, essentially. So
yep. These are just some sample languages. I don't feel the need to read them for you, but I wanted to provide for you some sample language in job postings related to being clear because of our formation and purpose, which is religious, charitable, nonprofit, 501c3. We have an organizational exemption from the prohibitions contained in Title VII of the Civil Rights Act of 1964 as amended. So I just wanted to provide for you some sample language about how do you actually say that.
Yeah, and you can find this from other organizations. Just find a well-known organization. World Vision's a good example. See what they're using on their job postings is an example, and just make sure whatever they're saying actually follows what you're doing, right? So
right.
There are several attachments for this week, and let me see if I can pull these up. So for this week, we have several templates that you can go through, and hold on, let me get to week 6. There's also some articles that go deeper into some of these issues, the religious staffing issues, this issue around at-will employment, how to write an employee handbook, more around religious hiring rights, and then we have some other links along those lines, and then we have some sample. So one is a human resources manual, and then we have human resources best practices checklist, and then personnel manual. So one of the things we're going to have you do is to go through this checklist, apply it to your organization, see if you're following some of the best practices, and then if your organization has a employee manual, then we want you to review that and provide recommendations based on the best practices. And you can actually look at what's in here. If your organization doesn't, then your assignment essentially is to come up with a plan on how you're going to get one, right? And to look at some of these existing ones and to provide recommendations. So hopefully that's helpful. Angie, this has been extremely helpful to me, and hopefully it'll be helpful to all of our students. So thanks a lot for your time, Angie.
Thank you.
Okay, all right, bye.